this is the quarterly chapter of Dorsey's interactive dialogue on IP issues. And today we're going to be discussing confidentiality clauses. So we will go ahead and get started. I know it seems to be a topic of particular interest. We've had sort of record-breaking registration for this program, so thank you all for your interest and your attention today. So we are going to talk about changes that are recommended to confidentiality clauses. Our speaker panel today is Chris Doerksen, a partner in Dorsey's corporate department in Seattle, and JoLynn Markison, a partner in Dorsey's labor and employment group. She's resident in Minneapolis. I am Jennifer Spaith. I'm a partner in the patent group. I also sit in Seattle. And so we've pulled this collection of people together this morning to really best address changes that we've been recommending clients make to their confidentiality agreements for a variety of reasons. And Chris will talk about those as they relate to the SEC. JoLynn will talk about those as they relate to the Federal Trade Secret Act and what's been going on there. They'll each speak, briefly about why we picked this topic and go over sort of what's driven that need. We got the question. I thought we would get the question throughout the program. It came in even before the program started about whether or not we'll have actual example clauses. We don't have actual full example clauses in this presentation. We're going to discuss the issues and the elements that we're recommending that get addressed in any language that you might add. We don't have full clauses in this presentation, but certainly, we're all here available to discuss that with you, and you're welcome to contact any of us after the program to discuss your particular needs. Given the distribution of this invite and the registrants we had, many of you on the webinar today are in fact, Dorsey clients already and are certainly welcome to reach out to us at any time. So, Chris, do you want to introduce yourself briefly and give a few comments as to why this topic is relevant, and we'll have JoLynn do the same.
Thanks, Jennifer. So I'm Chris Doerksen. I'm a partner here at Dorsey in our capital markets and corporate compliance group. I work with public companies as well as private companies on SEC compliance matters, raising capital, M&A transactions, and other corporate stuff. And this SEC issues that have come up on confidentiality agreements, we picked this as a topic because really within the last year, the SEC has taken quite a radical and aggressive approach to what they view as appropriate for a confidentiality agreement. And basically within the last year, they've taken the position that what you or I would consider to be a standard confidentiality clause is now in many cases viewed by the SEC as being illegal. And they've been aggressively going after public companies in particular, many of which have agreed to settle these cases, paying fines ranging from a low of $130,000 for the very first enforcement action to as much as $6 million for a large international company.
I am Jo Markison, and I am a partner in the Dorsey and Whitney Minneapolis Labor and Employment Group. And my practice really covers sort of the gamut of employment-related issues. I usually represent employers, but I also do work for individual employees from time to time, related to kind of everything you think about with basic employment issues, drafting agreements, upon the inception of employment, kind of seeing through different issues that arise during employment with respect to various statutes, and typically what you think of as like a typical employment issue, discrimination, harassment, etc. And then another part of my practice focuses on employee mobility issues, and that's what we're going to be talking about today. Specifically, I deal with trade secret protection. Oftentimes, that's accompanied by non-compete agreements or non-solicit agreements that companies have in place to protect their customer relationships and their confidential information. And the topic, I think, from the employment perspective, dovetails nicely with the SEC issues that have come into play over the last year. Specifically, a little less than a year ago, the Defend Trade Secrets Act was enacted, and that has some ramifications for employers as far as a different mode that they can go about enforcing confidentiality agreements and protecting their trade secrets. So that's really why I'm here today, and hoping to give you all some good tips about how to best craft your agreements so that you can have maximum protection under the Defend Trade Secrets Act.
Great. Well, so as we looked at this, and certainly internally, we've kind of pulled both of these concerns together to bear on individual changes to agreements that we recommend, and so that's kind of why the collection of people today. So we're going to start with Chris and the certainly more immediately eyeball-raising SEC enforcement angle. So Chris, why don't you go ahead and go through that?
Thanks. So first let's give a little background as to how the SEC came to this position, where they're coming from on the concept that a standard confidentiality clause might be illegal. So you all remember the crash in 2008, and that led to the Dodd-Frank Act in 2011, which was it covered a whole lot of different topics, but it was mainly aimed at additional regulation for banks and others in the financial industry to try to prevent what was seen as abuses that may have contributed to the crash in 2008. And one piece of that act was that Congress mandated that the SEC create a new whistleblower office, which was tasked with setting up a set of rules that would allow people to blow the whistle on companies that they believed were doing wrongdoing, and those individuals would be entitled to receive cash awards if that led to a successful prosecution or a successful settlement. And that's been in effect now for it's in its 6th year, and there's been more than $140 million paid to date to whistleblowers. So it's definitely a real thing. So in order to implement that mandate from Congress, the SEC had to adopt rules on a variety of different topics. Who is eligible to qualify as a whistleblower? What type of information would be acceptable? When would awards be made? And one of the rules that they adopted was a provision that prevented anyone from impeding whistleblowers. So we've reproduced that rule in part on your screen, Rule 21F17, that states in part that no person may take any action to impede an individual. In that context, that means a human being. So you're not permitted to impede a human being from communicating directly with the SEC staff about a possible securities law violation. And the rule goes on to give an example of that. You are not allowed to do that by enforcing or threatening to enforce a confidentiality agreement against that individual. So it seems like a simple concept that, if you've got an employee, Jim, who's threatening to call the SEC because he thinks that you're engaging in creative accounting or committing fraud against investors, you can't go to Jim and say, hey, Jim, you signed this confidentiality agreement. If you call the SEC, we're going to sue you on it. One note here as well is that while this is most relevant to public companies because public companies are subject to a much broader range of rules and there's a lot more that they have to do to comply with SEC rules, on its face the rule is not limited to public companies. It could apply to private companies as well. For example, when a private company is engaged in a securities offering, there could be some concerns about whistleblowers if exemptions from the securities requirements are not complied with, or if the information being provided to investors is fraudulent. So no one really thought that rule in 2011 was a big deal. There was no enforcement for several years, and then the first enforcement action was in 2015. And that got people to start taking notice, but it was kind of a no-brainer situation. You had a company, KBR, that would do internal investigations from time to time. And after those investigations, following an interview that an employee would have with the legal department, the employee would be requested to sign a confidentiality agreement saying that they would agree not to disclose any of the information to governmental authorities except with the pre-approval of the law department. And the SEC, required KBR to agree. This was an agreed settlement in a cease and desist order. KBR agreed to pay a $130,000 penalty and to actually communicate with not only current employees but former employees to tell them that notwithstanding that agreement, they were free to communicate with the SEC staff regarding any potential violation of securities laws, and that the company would not require either pre-approval or in fact even any notice to the company that those communications were occurring. But still, very clearly this was a company that was taking actions that you can see how it would be viewed as impeding whistleblowing. And when things really changed was last year. So last year, there was a number of enforcement actions between June 2016 and just before the new presidency. We've listed out here, there's at least 8 different enforcement actions where the SEC has gone after companies and those companies have agreed to settle. And what's really different about these is that in many of these cases, the SEC was not alleging that the company intentionally did anything to impede whistleblowers. They're, in many cases, not alleging that there was a whistleblower at all. What they're really been focused on is the language in the company's standard form confidentiality clauses. What they've been focusing on in particular is separation agreements with employees. They have looked at clauses and cited clauses that you or I would think are pretty common, such as an agreement recognizing, I as a departing employee recognize that I've been exposed to company confidential information. I agree that I will continue to keep it confidential following my departure, and I won't disclose it to anyone except to the company as required by law or with company permission. So that's the kind of clause that you see in just about any separation agreement. And the SEC basically said, well, if I was a whistleblower, theoretically, and I had that kind of agreement, well, wouldn't that prevent me from voluntarily going to the SEC to report a potential securities law violation? Well, it would, because they're not required by law to report that to the SEC. It's voluntary. So the SEC basically pointed to these standard confidentiality clauses and said these companies were offside. Effectively, they've said no company can ever again have a standard confidentiality clause like that without having a specific carve-out that allows the individual to report to the SEC freely without contacting the company and without getting their permission. Other things that they cited as violations include non-disparagement provisions. You can imagine, if I as a departing employee agree not to disparage my former employer, clearly that would prevent me from calling the SEC and saying, hey, these guys committed fraud. So those types of provisions, but also in the SEC's view, need to have a carve-out for reporting securities violations to the SEC. The SEC also looked at a few examples where after the 2011 rule, companies had gotten creative and they had included a carve-out in their confidentiality clause that allowed the individual to report to the SEC, but they said in the agreement, you, the employee, agree to waive any right to a whistleblower award. So a few companies tried to, follow the rule in saying that they could report and communicate, but tried to eliminate the economic incentive to do so. And the SEC has also taken the position now that that is not permitted, that the spirit of the law is to encourage people to report by having the economic incentive, and any attempt to prevent someone from getting such an award is in fact itself a restriction on communication and not permissible. So in those 8 cases, typically these are all they're all voluntary settlements. None of these companies were willing to litigate with the SEC over this issue. So they all agreed to a settlement where typically they agreed to pay cash penalties in the hundreds of thousands of dollars. But as I mentioned, there was one case that was actually $6 million. They've usually agreed to fix their agreements and policies going forward to have appropriate carve-outs. And they've typically agreed to contact any affected employee and specifically tell them they're now allowed to whistleblow and get awards.
And so, Chris, can you talk again about whether all those cases were public companies and what what causes us to think that private companies should also be looking at this? And we've had a question too about whether that also encompasses nonprofits.
Sure. Yeah, it's a good question. So I've gone back to the list of cases here. So you can see these companies. It includes, well-known public company investment firms like Merrill Lynch. BlackRock is a big investor. Home Street Bank, folks in Seattle may recognize as a local public company bank. There's also these are all public companies. When you look at issuers, you've got one in beverage, you've got some biotech, you've got some tech, you've got some natural resources. They're all public companies so far. They are the easy targets because public companies have to publicly file with the SEC their employment agreements with executives. So the SEC can really just go on their own website and see if you have clauses that in their view violate the rule. I'd say private companies have a much lower risk of the SEC coming after them. They're not going to be high on the radar screen. But the way that the rule is written, it says any person may not impede an individual. So it doesn't say public company. It doesn't even say company. So really any person could be any company or any individual that impedes someone from whistleblowing would be in violation of the law. So the next question that kind of brings you to, okay, well, the SEC is focused on separation agreements, but if the whole logic is that you need a whistleblower carve-out in your confidentiality clause, why would that rule apply only to separation agreements? There's really no logic to that. And so if you assume that the SEC's position is going to hold and they're going to continue to enforce on this basis, well then logically that seems to mean that your regular run-of-the-mill employment and consulting contracts would also need to have a whistleblower carve-out. And most companies that we deal with have company-wide policies, not just agreements, that also deal with confidentiality, things like disclosure policies, codes of ethics, employee manuals, those kinds of things. So if those things have confidentiality clauses that don't have whistleblower carve-outs, I think the same logic would seem to apply. And if you've got to have a carve-out in one, you probably have to have a carve-out in all of them, or at least a carve-out that's communicated clearly in one place that overrides anything that is inconsistent.
So on that point, Chris, I mean, you and I had spoken briefly about, what to do with all of this collection of policies. And so, are you seeing all of those get revised, or one that tries to sweep in the other, or what ends up actually happening there?
Yeah, so that's a good question, Jennifer. And so not every company is taking the same approach. I skipped a slide here about unanswered questions, which kind of goes into the risk analysis, but we'll get to that next. But as to what we were recommending people do, at least prior to Trump taking office, when this was an ongoing thing that was happening, every week you'd see a new enforcement action. What we were recommending is, clearly forms of agreement that don't, you don't have to go back and amend something. It's just your form you're using with new employees, new consultants, et cetera. There's really, you should think about updating those forms to include a whistleblower carve-out. That is one thing that you can do that is really low impact because it doesn't require changing anything. Beyond that, really we're suggesting people think about what will work best for them. On the most extreme approach, the most conservative, you would actually amend every single agreement that you have that is with an individual to add the whistleblower carve-out, and you would amend every single company-wide policy that you have. And we're tending not to see many people want to do that, especially those with large numbers of people. So I've had a number of companies that I've worked with that have settled on something more straightforward. So for example, if you are about to update your code of ethics or you have a company-wide policy, you could update that, and you could have a carve-out that by its terms overrides any other agreement the individual might have with the company. So it could include a clause, something like, notwithstanding anything in this policy or any other policy of the company or any agreement between you and the company, you're advised that you have rights under whistleblower laws to communicate directly with the SEC staff regarding potential securities law violation, and nothing in any of the company's policies or agreements are intended to prevent you from doing that. If you have that kind of clause somewhere and you can prove that that was clearly communicated to people, then it would seem to me it would be much harder to have the SEC say that you are impeding whistleblowers. Similarly, with existing employment agreements, a lot of companies are deciding, we really don't want to go there, but next time we amend that person's agreement, we'll fix it then. Another area where we're seeing people not necessarily do the full meal deal as far as what the SEC has been requiring of the people it actively goes after is with former employees. Talking with companies, I'm finding a lot of companies just don't have the appetite to try to track down all their former employees and say, hey, former employees, by the way, if you ever thought we did anything wrong, call the SEC and you may get an award. Most companies are deciding that that creates more risk than it solves. But that's something every company will have to consider for itself. So there are some unanswered questions that make it a little harder to decide exactly what to do at this point. One is the big one, and as I mentioned, there were 8 additional enforcement actions on this basis. The last one was the day before Trump took office, and there has not been an announced enforcement action since Trump took office. The president has been quoted in the media many times as saying that he is not a fan of Dodd-Frank as a whole, and that he wants to repeal or push back on a number of the rules under Dodd-Frank. I haven't seen any specific discussion to this issue, but there is certainly the possibility that the SEC will not continue this line of enforcement actions. But I'd say it's premature at this point to conclude that there's no worry, in part because the SEC Commission is woefully understaffed right now. The Commission is supposed to consist of 5 individuals, usually 3 that are part of the President's party and 2 of the other party. And the Commission right now only has 2 members, 1 Republican, 1 Democrat. The process of appointing a new head commissioner is still ongoing, and so this may just be a breather that we're seeing while they try to get their internal house in order to figure out, well, who is the commission and what priorities are they going to have. So it may be some months yet before we know if there's really been any change or if they've just slowed down on their enforcement actions. The second unanswered question is the one that Jennifer raised. Will they go after private companies? I have to think that they won't aggressively go after private companies. That if it comes up, I think it would probably come up in the context of an actual whistleblower. If there's someone who's actually trying to blow the whistle and prevented from doing so because of an agreement, I could see the SEC stepping in at that point. Absent that, I'm not sure what would put a private company on the SEC's radar. But the rule itself, as I mentioned, is not limited to public companies. So that's more of a risk analysis than a real legal argument as to why private companies shouldn't have to worry about this. And then the last one is, it's not really clear why the SEC has been going after only companies and only with respect to separation agreements. I think once we know the answer to the first question as to whether this policy will continue under Trump, if it does continue, I would expect that over time the SEC won't be limiting themselves to separation agreements. I would expect that they will start to bring enforcement actions based on other agreements, because there's really just no logic behind limiting themselves to worrying only about separation agreements.
Thanks, Chris. And can you just kind of, by way of summary, go, underscore overall the risk in not addressing this in a company's agreement and the timing that you've seen companies take in approaching their agreements, in terms of, are they getting revised immediately, or what's been the timing for that?
Sure. So yeah, at this point, there's really 2 possible approaches. Those who feel confident that Trump will scale back enforcement could take a wait-and-see position if they have not already updated their forms. Those that aren't comfortable with that position should do something to change their forms, because the risk is that the SEC will come after your company, and you will be required to spend money on lawyers and defense, and then in all likelihood, being required to spend several $100,000 to pay a fine, to be named publicly as having violated the law, and having to then go out and communicate with all of your employees and former employees to specifically tell them that they can whistleblow. With former employees is a higher risk group than current employees. So, you may be better off, particularly public companies, to take action that you think is good enough to prevent the SEC from really going anywhere should they ever inquire about what your practices are.
Great. Well, thanks, Chris. And Chris is going to stay on the line. We're going to turn to Joe here in a minute, but Chris is certainly still here. So as you're hearing the rest of the presentation, if you have additional questions, please do go ahead and continue to ask those, and we'll all be able to address those. In considering these changes to confidentiality clauses, the other thing that we wanted to raise and turn to that's also has impacts for confidentiality clauses. Of course, every time we're thinking about confidentiality clauses, we're thinking about trying as best we can to protect the trade secrets of a company. So we definitely want to turn to some consideration of how to best be protecting trade secrets, but also in light of the recent Defend Trade Secret Act, which lends some federal protection to trade secrets. There are some specific benefits there offered for particular changes that you might make to confidentiality clauses. So we wanted to look a little bit at how both of these come into play, and should be considered as you're making these revisions, which might be driven, by either one of these concerns. So, Joe, do you want to first kind of give some background as to the Act and where we're at?
Absolutely. So the Defend Trade Secrets Act is almost a year old as far as enforcement is concerned. So it's effective for all trade secret misappropriation claims that occur after May 11th, 2016. So we're coming up on the 1-year anniversary. And one thing that this Act does that wasn't previously available is it creates federal subject matter jurisdiction for trade secret misappropriation. And this is kind of a big deal because before this Act, the avenue that litigants had to take was basically through the state court system unless there was some other basis for federal jurisdiction. So for instance, if a company in Minnesota was suing a company in Colorado, there would potentially be diversity jurisdiction, which would get you into a federal court. But the default for misappropriation of trade secrets has always been state court venued. So this just creates sort of the immediate bump to the federal court system. And we'll talk a little bit later about some of the benefits that come along with that. But that's one really noticeable change. With respect to sort of the nuts and bolts of the Defend Trade Secrets Act, it's pretty similar to the Uniform Trade Secrets Act. And most states have adopted some version of the Uniform Trade Secrets Act. So basically, the definition is very similar. It has similar remedies to many of the state Trade Secrets Act. It has a 3-year statute of limitations. And that limitations period begins to run at the time on which the misappropriation is discovered or should have been discovered with appropriate diligence. Another important thing about this is that it doesn't preempt state law. So in theory, a company could bring a lawsuit in federal court and they could assert a claim for violation of the Defend Trade Secrets Act, and they could also assert a separate cause of action for violation of whatever state Trade Secret Act applies. It just basically gives 2 different avenues to obtain recovery, And the remedies are similar under federal and state law, but depending on which state you're in, there could be some differences as well. So it just adds sort of another layer of protection and then another avenue for redress. One important thing about the Defend Trade Secrets Act is that unlike many state laws, you can't get injunctive relief based on the inevitable disclosure doctrine. So basically the inevitable disclosure doctrine is that you say, hey, look, this employee that I used to have, they've got all this information stuck in their head. They know everything about the company. They know who our clients are. They know how to get a hold of our clients. And so we want to be able to protect that. Well, under the federal statute, you can't really protect that. So you can't say, you can't say they're going to a competitor and they're going to automatically use this information if they're going to do their job. So basically that's the inevitable disclosure doctrine is they can't really perform this work for another competitor of ours without using this information. That's not going to be good enough under the Federal Trade Secrets Act. There has to be actual threatened misappropriation. So if we take a look a little bit closer at the Defend Trade Secrets Act, the definition, again, pretty similar. It protects all forms and types of financial, business, scientific, technical, economic, and engineering information, the same way that most state statutes do. There are a couple of qualifications. So whatever the trade secret is, the owner of the trade secret has to have taken reasonable measures to keep the information secret. And the information has to drive independent economic value, which is the term of art here. So it has to have value by the fact that it's a secret. Some examples of trade secrets, so proprietary data of a regulated industry, designs, identities of suppliers, and customer lists, which is actually this is an expansion and a difference between the Federal Trade Secrets Act and a lot of state statutes. A lot of states don't actually protect customer lists or the identity of suppliers as trade secrets, and that's why when I say it's nice to have a couple different avenues. So let's say you bring a state trade secret claim, you can bring the federal claim as well. Well, under the State Trade Secrets Act, customers might not qualify as being trade secret eligible, but under the Federal Act they are. Some examples of things that are not a trade secret would be architectural plans that are filed with a government agency. And again, that's because you're making them public, you're filing them. The identities of suppliers that are discoverable by people who seek them out. So if it's really easy to go out and figure out who suppliers are, then that's not going to be protectable. And also information that's generally known in an industry is also not protectable under the Federal Act. With respect to reasonable efforts to protect a trade secret, some different ways that you could do that are advising your workforce about the existence of a trade secret. And you can do that, you can explicitly call that out in employment agreements or in independent contractor agreements. Also limiting access on a need-to-know basis and controlling physical access to trade secrets. So a lot of companies will do that by requiring employees to log in and use password information when they're accessing trade secret information, or having a clause when you log into the computer that says, you will be accessing trade secret information. By clicking, you agree that the information is trade secret, and you reaffirm that you're not going to use it for the benefit of anybody other than the company. Another really helpful thing about the Defend Trade Secrets Act is that it provides for Exparte Seizure. So this is available only in extraordinary circumstances. So if you think that there is a high probability that the person who's taking your trade secret is going to destroy it or make it inaccessible, then you can move for immediate seizure of the trade secret. It will be carried out immediately. And what happens is the property is seized and it's taken into the custody of the court. And then there's a hearing that's happens within 7 days after issuance of the seizure order. So if you're going to avail yourself of the seizure protections of the Defend Trade Secrets Act, there are a couple things that you should be aware of. The first is that the person who is obtaining the seizure, so if you're saying, okay, I need to send the sheriff and he needs to go get this property, you're going to have the burden of proving facts to support the findings of fact and conclusions of law necessary to support the order. So you're going to really need to be able to demonstrate with concrete facts that there actually is a risk that the property is going to be destroyed, moved, hidden, or otherwise made inaccessible.
And Joe, paint us a little picture of that. What would be the likely situation in which this would arise? This is where you have a angry departing employee who's taking a thumb drive with him that has some trade secret material, or what kind of context is this? Would you expect to see something like this be helpful in?
Sure. So, I think you kind of hit on the classic example, which is the disgruntled departure. And I think it's probably also industry specific. So if you've got an employee who, by virtue of the work that he did for the company, has access to highly sensitive trade secret information, or, that employee was actually working to create some sort of patentable device for the company or some sort of patentable process, then the employee leaves. If the employee takes with them trade secret information, and I guess one example would be, let's say this employee is one of the few people who's got access to the trade secrets. So they've taken them, and now the company might not even have access itself to those trade secrets. If there's a fear that that employee is going to take them and is going to destroy them in an effort to hurt the company, then that would be sort of a classic example of when you can go in and avail yourself of this ex parte seizure process. And the risk associated with that is that if the person who, let's say the person you're accusing of taking this trade secret information, let's say you're wrong, and that person suffers damage by a wrongful or an excessive seizure, then you could potentially be liable. That person would have a cause of action against the company at that point. So let's say I terminate an employee. The employee, I think, has taken with them trade secret information. I want to avail myself of the seizure procedure. So I get the court involved. A police officer goes out to seize the property, and let's say it results in some sort of altercation and this person is injured or hurt, or their property is injured or hurt, and then we find out later on that I can't support the facts that would have really justified the seizure. Well, that former employee can then come after me for damage to his property or damage to his person as a result of the seizure procedure. So that is one of the risks with this, is that you want to be fairly sure that the risk exists before you avail yourself of it.
I had a couple of questions, Joe, about those standards. Is there do you happen to know initially what that threshold is for, getting the seizure to occur, and then B, what the standard is at the hearing? Are you showing, do you need clear and convincing evidence? Do you need preponderance of evidence? Do you happen to have that?
Right now, offhand, I don't, and I'm not sure, I'm actually not sure that law has been developed yet. But that's certainly an issue that I could attempt to find out and then and let people know, or let the person know who is wondering that.
Yeah, sure. But suffice it to say, though, also then, let's talk about the import of the DTSA for confidentiality agreements as well.
Okay, so one important thing is we had previously talked about how the SEC is looking into whistleblower issues. The DTSA also addresses whistleblower issues. It contains provisions that have ramifications for confidentiality agreements, not only in employment agreements, but also in independent contractor agreements. So basically what it says is an individual can't be held criminally or civilly liable under the DTSA for disclosing a trade secret in confidence to any governmental official or to an attorney in a complaint or other document filed in a lawsuit or other proceeding, so long as that is filed under seal. So really what this means is, so that's the carve-out, and an employer, to avail itself of all of the remedies under the DTSA, has to provide notice of that immunity and any contract or agreement that governs the use of trade secrets or confidential information. So, concrete example, in your confidentiality agreement, your standard confidentiality agreement that you have with all of your employees, there's often, a definition of what confidential information is, and then there's a prohibition against disclosing confidential information to anybody outside the company or to people who don't need to know, or using it for anything other than company purposes. That agreement has to contain language basically that provides this carve-out for providing trade secret information and confidential information to government officials or in lawsuits or other proceedings, as long as it's filed under seal. And this applies not just in employment agreements, it applies in independent contractor agreements as well. So it's not necessarily just with respect to employees, it extends beyond that. It is sufficient, so if you don't want to include specific language with the explicit carve-out, you can cross-reference a policy or other document that you have that's available to employees that contains the more specific language and carve-out about whistleblower protection. So for instance, you could say, this confidentiality clause is subject to the policy, the company's policy regarding whistleblower protections, and then you could cross-reference it and refer them to where they can find that other policy, whether it's on a website or in a handbook that's available in hard copy format, which doesn't usually happen these days, but that is going to be sufficient under the Act. So the risk of not including this is that the failure to disclose the whistleblower exception defeats the employer's eligibility to recover double damages and attorney's fees in litigation. So the DTSA, it has a provision that allows for multiplied damages and attorney's fees in a lawsuit where the employee has engaged in willful and malicious trade secret misappropriation under the Federal Act. So basically, by not including this provision, you're losing out on those multiplied damages and your chance to recover attorney's fees. So what does this mean for companies? I think it's a good idea to kind of reevaluate, given this additional forum to protect confidential information, reevaluate the company's tolerance for bringing trade secret claims. One of the benefits of being in federal court is that a lot of times there are smaller caseloads and there's less delay. And so a case can move more quickly through federal court sometimes than it can through state court. So this gives that other avenue of obtaining relief. The other thing is companies should probably use this as an opportunity to take a look at their materials and evaluate what types of protections they are giving to confidential information. One thing that companies could consider doing when drafting their confidentiality clauses in their agreements is to specifically call out sensitive information as trade secrets in order to strengthen a potential claim under the DTSA. So you've got your standard definition of confidential information, and often there are a bunch of examples. This is what confidential information is. So go back to your agreement and also include not only is this confidential information, but it's also these are trade secrets of the company, and that will strengthen a claim under the DTSA. In addition, when companies are looking to enforce breaches of confidentiality agreements, consider bringing a DTSA claim at the same time. Given the sort of broader protection under the DTSA, it's possible that although the information might not qualify as a trade secret under a state statute, it would under the federal statute. And so that's just another avenue. Another thing that companies can do is decide in advance how to respond to suspected misappropriation. So come up with sort of a strategy. Train your HR people and your managers about, okay, when a person departs, here's what we need to be looking for. We need to make sure that we tell them they need to return everything. We need to, check in their computer, make sure they haven't deleted anything off of it. You can also, I've got some clients who have asked me to, in advance, prepare for them sort of a template brief and complaint that's got all the information about their company and their trade secrets, explains their business. And so really it leaves for me to do in the event of an emergency where we think an employee has taken something, it leaves just those facts to be filled in. And in that way, a company can move a lot quicker, which is important when you're looking at somebody stealing your trade secrets. You can move a lot more quickly into court in that scenario. And that might not make sense for all companies, but it might make sense for companies who deal with sort of non-compete and trade secret issues on a more frequent basis. If that's not your company, one thing that you can do if you don't want to undertake those steps right away is you could talk with an attorney who handles matters like this and sort of set up in advance, hey, in the event that our company runs into this, is this something that you could handle? And you could talk with that person about how it looks at, how that would look like, so that you've got counsel lined up in advance, and you don't have to be scrambling to interview people, when you're in crisis trying to recover this type of information. Which brings me to sort of the end. So we're talking about trade secrets, and I just want to reiterate that companies can protect more than just trade secrets. So this doesn't limit the company's ability to protect other information that may be confidential that doesn't qualify for trade secret protection. Confidential information is broader than a trade secret, and you can put in your employment agreements and non-disclosure agreements and any other type of agreements whatever definition you want for confidential information, as long as it's not information that's publicly available or in the public realm. So that's just something important to note. And then examples of agreements where you can have confidentiality clauses and where you can try to avail yourself of protection under the DTSA. I've listed some here: employment agreements, non-disclosure agreements, severance agreements, also consultant or independent contractor agreements, license agreements, reseller agreements, and strategic alliance agreements can all have confidentiality clauses in them. So.
Great, thanks, Jo, and thanks to both of you again for joining us. I think I'd like seeing the material side by side, because I think if your eyebrows have been raised by the SEC actions Chris was talking about, and you're going to go through the trouble of reviewing your confidentiality agreements and terms, certainly reviewing them also in light of the DTSA and ensuring that your whistleblower carve-outs comply with both what the SEC is looking for and what is required under the DTSA to avail yourself of all of the benefits of that act. Kills a couple birds with one stone if you're revisiting agreements. So I think it's helpful to keep both sides of the house in mind. Certainly, if there are questions, I know some people would like to delve deeper into actual language or benefits of the DTSA or approaches and particular risks for their company. We're certainly all available to reach out to for those kinds of questions or follow up on the program or any other matters that have come to mind. So all of our contact information is here and also will be distributed in the program and materials. So do always feel free to reach out to us or any of our other colleagues here at the firm to discuss these issues. We do run a quarterly IP webinar, and our next one is scheduled here in July, which will be myself and a trademark copyright brand management partner, Jeff Cadwell, talking about design feature copyright protection for designs and the recent Star Athletica Supreme Court decision regarding cheerleading uniforms. So look for that invite as well, and please do join us for that program. Thanks again to everyone for their attendance today, and I will put up again all of our contact information should you have any follow-up questions. Thanks again, and have a wonderful day.